Due Process awarded 9 Emmys, including the 2005 New York Emmy for Outstanding Crime Reporting Programming.
I have this background of representing all of these persons that the government has declared to be enemies, so some of them very successfully, and so I was ripe for the picking, as they might say.
She made her reputation on representing radicals. Now Lynne Stewart herself is facing prison. The government says she broke the law on behalf of this convicted terrorist. Should she be disbarred, even in prison? And what's the message here to the criminal defense bar? That's up next on Due Process.
Major funding for Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy. Additional funding provided by Lawyer's Diary and Manual and online legal reference, elaw.com.
Her conviction met with both cheers and outrage as a federal jury found her guilty of giving support to a terrorist conspiracy. After nearly 30 years as a people's lawyer and a lifetime as a political radical, Lynne Stewart may be headed to prison. Should she have been prosecuted at all? Should she be locked up for the rest of her life? And what are the implications for the criminal defense bar? I'm Raymond Brown, and we're talking today about a case that has split the legal community, as we'll see here in the studio. But first, Sandy King with a look at the woman who's created all this furor.
Raymond, she is the grandmother of 14, a breast cancer survivor who is used to being in the trenches. But now the fight is for her own survival. So Lynne Stewart is contesting her conviction as the government appeals her 28-month sentence, still insisting she should get 30 years. Martyr to the cause of freedom?
Front page of the freaking paper, Lynne Stewart!
Or tool of the terrorists?
Lynne Stewart!
Enemy of the state.
Was conspiring with a freaking terrorist, Sheikh Omar Abdul Rahman.
Just look her up on YouTube, where anyone can post practically anything, and you'll find a lawyer as loathed.
Now this lawyer who aided and abetted the terrorists
As she is loved. But is it roses that Lynne Stewart deserves? Or is it life in prison?
She received her day in court. She had every opportunity to make whatever arguments needed to be made on her behalf. The case went to a jury, and the jury decided. That's the American way.
And 30 years of virtual life sentence was what Lynne Stewart faced when a federal jury in Manhattan found her guilty.
In ordinary times, this would not have been a criminal case. But these are not ordinary times.
Guilty of violating national security by carrying messages from a notorious convicted terrorist, Omar Abdul Rahman, once based in Jersey City and dubbed the Blind Sheikh, held incommunicado in a federal prison. The government said her knowing acts to get his word out amounted to no less than treason.
The fact that it's in the context of terrorism just compounds, again, a visceral negative reaction, both from the public and from the prosecution.
So after 3 decades as a lawyer, her reputation based on her representation of radicals and revolutionaries, Lynne Stewart herself was looking at life.
I have this background of representing all of these persons that the government has declared to be enemies, so some of them very successfully, and so I was ripe for the picking, as they might say.
And it was all a far cry from the fresh-faced small-town girl who traded in the safe life as a school librarian for the passion and perils of a people's lawyer. one who'd come to the People's Law School to learn her trade.
I think she came to law school because of who she was, because of her attraction to Arthur Kanoy, his commitment to protecting the poor, the powerless, the disadvantaged minorities.
And at Rutgers, it was Arthur Kanoy, a civil rights icon who had even represented the Rosenbergs, who was her inspiration.
I said, I can be a lawyer, I can go to court, I can be one-on-one with these people, I can do some good, I can at least rescue one at a time.
But as a lawyer, she found a mentor in the lightning rod, Bill Kunstler, who shared her politics, her practice, and her activist approach to their controversial cases and clients.
And we're not lawyers who will reveal secrets, and we don't even know them.
You really have to have something in the stomach for it. You have to want to do it. It's not enough to think, oh, this would be fun.
So when she agreed to defend the dreaded sheikh, charged with plotting to bomb New York landmarks, linked by the government to the first attack on the World Trade Center, it was with her usual fervor.
He really was a tremendously charismatic person.
And even after Abdel Rahman was tried and convicted, locked away in isolation, Stewart continued to visit, agreeing she admits to strict government rules, restricting his communication to the outside world.
And so the government's allegation is not just that she was the conduit or assisted in carrying messages from her client to others outside the prison, but that she specifically violated the agreement that she had signed with the government.
But she insists that when she broke the rules, even talking to reporters on his behalf, it was not, she says, in support of his cause, the alleged violent overthrow of the government in Egypt.
I would love to practice again. I said in my letter to the judge before sentencing, I said, the worst punishment is not being able to practice, to be in front of a courthouse at 9 o'clock in the morning and not be part of that. That is the hardest.
I think that what happened here was that she's a perfect example of the public seeing the lawyer as the alter ego of the client. And having been perceived that way even prior to the allegations, and being a very vehement defender of an alleged terrorist caused her to get into the trouble that she did.
A person who has done so many good works, should she be deprived of liberty for the rest of her life because she lost her sense of judgment for a moment?
And in the end, the judge said no, rejecting the government's call for 30 years, sentencing Lynne Stewart to 28 months.
This is a great victory against an overreaching government, and I thank all of you for that victory. You all had a part of it. You all are part of me. Amen. Thank you.
In her letter to the judge before she was sentenced, Lynne Stewart wrote, "I am not a traitor. The government's characterization is inaccurate and untrue. It takes unfair advantage," she went on, "of the urgency and hysteria that followed 9/11. And the sheikh had been convicted of plotting terrorist acts against the U.S. But the target of those messages that Lynne Stewart helped get out were aimed not at America, but at the Mubarak regime in Egypt. Stewart has enthusiastically embraced many causes throughout her life, but that, she says, Raymond, wasn't one of them.
And when we come back, Stewart's one-time adversary in the case against the sheikh, a counterterrorism consultant, and a Stewart supporter from the National Association of Criminal Defense Lawyers. So stay with us.
Lynne Stewart, she's the one who represented the individuals from the Middle East, is that correct?
She was the one who was convicted for supposedly aiding the guy with terrorist connections.
She was the lawyer for the blind sheikh.
Is she the jailed lawyer?
I think it had to do with relaying information from the person she was representing from
from the jail.
She got in a lot of trouble because apparently she unwittingly or wittingly passed information to some other group or something like that, terrorist related.
I don't know who she is. Should I?
She is Philadelphia DA, perhaps?
I have no clue who that is, to be honest.
Well, she was convicted, I think, of treason. I'm not so sure of the specific counts, but I know she's serving time for aiding and abetting terrorism, I think.
So even at Rutgers Law School, where we did those interviews, Lynne Stewart wasn't all that well known. But lawyers know exactly who she is, and chances are they have some strong feelings. We'll get an idea of just how strong from Andrew McCarthy, who led the prosecution of the blind sheikh, from David Gartenstein-Ross, counterterrorism consultant and author of My Year Inside Radical Islam, and in Newark, from Marvin Schechter, past president of the New York State Association of Criminal Defense Lawyers. Welcome to all of you. A bit of disclosure, I'm the former president of the New Jersey Association of Criminal Defense Lawyers and a former board member of the National Association, though I was not involved with the briefs filed in this case. Marvin, let me start with you. An obvious question would be, do you think that this prosecution should have been brought at all, and if not, why not?
Well, it shouldn't have been brought at all, because in the final analysis, what Lynne Stewart really did was issue two very public press releases, one in 2000 and another one immediately after that, clarifying a statement made by the sheikh concerning a ceasefire that his followers were following in Egypt against that government. It was that press release and the subsequent one which were the violation of certain rules and regulations that she had signed as a lawyer.
Let me ask you to clarify it. She had signed an agreement saying that she would not communicate in that way. Is it your view that those agreements should not be binding, or that the law is bad, or that discretion was improperly exercised to bring about this prosecution?
Well, I think the discretion to bring about the prosecution was improperly exercised. The way to have really handled that was to engage in an administrative procedure, which would have had far-reaching consequences for Ms. Stewart's access to her clients, not only the sheikh, but even entering federal jails, and would have sent a very harsh message to the entire criminal defense bar. Attorneys are very sensitive to these kinds of things. But to then elevate a public press release, two of them, into a material support for terrorism case seemed to me not only overreaching, but just, overkill
Let
in this
me
case.
ask David, who's busily shaking his head no, whether you agree that it was overreaching to prosecute, and whether administrative sanctions for violation of those SAMs, the regulations governing what lawyers can say, would have been more appropriate.
I don't agree that it was overreaching to prosecute, and I think that one thing Marvin glosses over is what precisely these press releases were. They weren't just press releases that were clarifying something concerning a ceasefire. They were press releases which showed definitively, when Sheikh Omar's supporters were skeptical, that he wanted to end Jamaat Islamiyah's ceasefire with the Egyptian government. Now, it's important to understand what Jamaat Islamiyah did when they weren't under ceasefire. In 1997, a number of Jamaat Islamiyah members went into the temple of Hatshepsut in Luxor, Egypt, and murdered 58 foreign tourists as well as 4 Egyptians. Now, that was particularly, it stood out particularly for me because I'd been in that temple 2 weeks before. I mean, it's a major tourist attraction. You have an area where you're walking through the temple. There's no exit. They went through and slaughtered everybody. Like, this is a group, what they did is no secret.
But the predicate involves, Andrew, the fact that the defendant or the convicted person, the sheikh, was held incommunicado. Right. And that at least Lynne Stewart's lawyer has argued that she had a lawyer-related reason for talking about the sheikh and issuing the press conference. That is, to keep his case alive, to hopefully put pressure on the government to change its view about whether he should go back to Egypt. So, without regard to whether you agree that the strategy was sound or not, why would these competing interests not result more effectively in an administrative sanction as opposed to a criminal sanction, the issue Marvin's raised?
First of all, it's not lawyer work at all. People need to realize that by the time this all happened, the blind sheikh had had his trial, he had had his appeal, his time to appeal to the Supreme Court had run, and his time to file habeas corpus petitions attacking his conviction had run. He was no longer an accused under the First Amendment, and she was no longer acting in the role of a traditional defense lawyer. So you have that on one side of the equation. On the other side of the equation, you have the fact that this particular defendant is one of the worst terrorists, worst defendants who's ever been prosecuted in the United States. He's the person who Osama bin Laden says gave the fatwa that authorized the attacks of September 11th. So to me, it's no contest. You have somebody who's not acting as a lawyer, who's enabling one of the worst offenders that we've ever had in the history
She
of
must
this
have been,
country.
she must have been acting as some kind of a lawyer because the government required her to sign agreements as a lawyer to go see her client as a lawyer. So I'm not quite sure that that kind of analogy holds true. And to say that her lawyerly obligation ended because the time for her habeas and other legal remedies had ended is not to say that she wasn't engaged in lawyerly activity. And even if, as a lawyer, she went and held a press conference and a press release in which she puts very open and notoriously, it can't seem to me that that is anything comparable to, say, for example, Richard Reed, who lights a match in his shoe on an airplane to try and bring down an entire passenger ship with huge loss of life. That's a terrorist case. This was not a terrorist case.
Debbie.
That fundamentally misunderstands the way terrorist groups function. The way that they function is they're very reliant upon a higher authority that will declare whether they can be at war or whether they're not at war. Sheikh Omar Abdel Rahman for Jamaat Islamiyah was that higher authority. He was someone who the terrorist group's members looked up to. If he said the ceasefire was on, they would go with the ceasefire. If he said the ceasefire was off and null and void, they would resume hostilities against the Egyptian government. So that very much underestimates and overlooks the way these groups actually function.
Andrew, although the regulations governing lawyer relationship with clients have changed, were in place to some extent before 9/11, post 9/11, there's really been a ratcheting up of restrictions as well as videotaping those conferences, profoundly changing the way lawyers relate to their clients.
Well,
that's one of the reasons I think that there has been so much concern in the criminal defense bar in general and perhaps the bar more broadly about the implications of those restrictions. Do they trouble you at all?
No, because again, it depends on whether somebody is pre-conviction or post-conviction, particularly as we're dealing with this instance. People need to understand, when the blind sheikh was on trial, when he was presumed innocent, he had some of the best legal assistance that a defendant could conceivably have. He didn't have one lawyer, just Lynne, he had three. They were able to present a very robust defense. They were able to meet with him quite freely even after his conviction when he was preparing his appeal.
He is no longer entitled to any legal representation after his conviction or even after his remedies have run their course.
Well,
while there are other options, either arranging with other governments to make arrangements with the United States or advocating for a client. That's why the government let him.
That's not legal work in my mind. We're talking about, you want to talk about the role of a traditional...
Why was she allowed, let me ask you this, because Marvin raised this point before, why was she allowed to visit him and why did she sign one of those forms that is essentially for lawyers?
Because we happen to live in a country where we continue to allow people to meet with their lawyers even after their convictions are final.
Purpose?
And in fact, they're able to, if there's a basis for it, challenge the conditions of confinement of the individual. Now, it happens that this particular individual is one of the best cared for defendants in the United States.
Marvin? Andy, if she wasn't a lawyer engaged in lawyerly work, then the government had the absolute right under those rules and regulations to prevent her from seeing Sheikh Abdul Rahman. She could have done the same thing that you're advocating
Marvin,
now.
let me ask
it could have been challenged
Marvin,
by the government. They didn't. They let her see her client.
Marvin,
so
let
she
me
must
ask
have
a
been doing
question which
lawyerly work.
addresses perhaps why this issue has been so widely followed among lawyers. Does it have implications for representation of accused or persons who are in a post-conviction status? I mean, that's obviously one of the issues on the table. Are there broader implications for this or not?
There are much broader implications. It's now pretty clear with hindsight that one of the central components of the Bush administration's war on terror was really the whole role lawyers played. The Bush administration was determined from the very start, 6 months after 9/11, that it was going to go after terrorists. And one of the component parts of that strategy was to make sure that if they had due process rights, they were going to really make it very, very difficult for lawyers to enforce those due process rights. And when you start to have situations where lawyers are being spied upon in their conversations with their clients through FISA warrants or otherwise, the implication for the defense bar as a whole is very clear. I'm not taking one of those cases. I can't worry about a statement that I may make out of context or in context in the course of advising the client
Let me
that
go
the
to
government picks up on.
Let me go to David and then Andrew. David, you're a counterterrorism consultant, but also a lawyer by training.
Right.
Is it your view that there is a point, even while in post-conviction status, that you can extinguish a person's right to counsel or severely restrict it if the person has been convicted of a terrorist-related offense?
You may be able to severely restrict it. I think...
What about the fact, the key here, for example, which is the government can overhear and record anything that's said between lawyer and client?
Well,
is that troublesome to the lawyer part of your experience?
Yeah, I think that it is troublesome, but I think also in this case there's a balancing of interests. One of the things that you have experience with in the legal system is lawyers who have smuggled messages out of cells on behalf of terrorists. That happened in the Lynne Stewart case, for one. And also it's worth noting that all of the restrictions that Lynne Stewart harbored under were under the Clinton administration. None of them came up
greatly enhanced, including the videotaping post 9/11.
They certainly were enhanced.
And by the way, Clinton, because Clinton did it, probably only makes it bipartisan, not necessarily good.
Right.
I'm not saying that makes it good or bad. I'm just saying that the issue of the Bush administration, because these days, like, Bush administration, obviously very unpopular, and I'm certainly not a fan either.
It's a fair argument. I was just asking.
Right, but part of it is that's kind of a trigger word, and it's important to note that these special administrative measures preceded the Bush administration entirely.
I just think Marvin's nightmare scenario is so divorced from reality as to be night from day. We actually, first of all, there's no record of lawyers being heavily prosecuted since 9/11. You have this particular case, and
wouldn't that justify something that Lynne Stewart says, which is she thought she'd be treated administratively for this, and that was her expectation? Wouldn't that affect discretion?
Actually, I think
that's
a factor to her detriment. I would say if she was figuring she was going to violate these, but it would only be handled administratively, I'd say that's a point against her, not for her. But my point is, not only has there not been a record of prosecuting lawyers, but if you take a look down at Guantanamo Bay, you have lawyers who are basically tripping over themselves to go down there and volunteer to represent.
But that's another show, and we'll bring you back for that.
Well, but what he said is that lawyers don't want to take these cases.
Marvin,
lawyers can't wait.
Let me take you a place
cases.
I know you don't want to go, but given your opposition to the prosecution, the sentence 28 months when the government's asking for 30 years, your reaction to that?
Well, a pretty stinging rebuke. You know, I can't go into the mind of Judge Kodal, but he's a federal district court judge presiding over one of the most high-profile cases in history. The government says, give this person 30 years. The judge does two things. One, he sentences her to 28 months, thereby, in his mind, fitting the punishment for the crime
Marvin,
convicted.
given the appeal, put on your crystal ball, you got to give me a one-word answer. Is the sentence going to change? Is she going to wind up with 28 months, or is the government going to prevail and get either heavier time or 30 years?
I think the conviction is going to be overturned, and we're going to start from scratch.
You're cheating, Marvin. But, Andrew, your view?
I think the sentence should be increased, but it won't be. The conviction will be upheld. And
how far would you increase it?
I think she's got to have 10 years at least for this offense.
And you predict that as well as think that's correct?
No, I think the court will uphold the sentence. The judges have great discretion under the...
David, what do you think?
I agree with Andy. I think the court will uphold the sentence. I think it should be higher. I think, in particular, the rationale given for making the sentence lower was outrageous, in that he could have given a downward departure because of her medical condition. Instead, he talks about a lifetime of good work. But remember, she was a highly political attorney.
Would you push it as high as 20 or 30 years?
Probably not 20 or 30. I'd probably give her at least 5, probably around 10.
And your reaction, if the court somehow wound up in the range of probation, what would you think the implications of that?
I would think it was outrageous. It's only by sheer dumb luck that nobody died as a result of what Lynne Stewart did. The fact that she did something that endangered many lives, but it just happened that nobody died, that really doesn't exculpate her at all. What she did is a terrible thing that should be punished.
Marvin, how hopeful are you when you said that this conviction will be overturned? Because I just want to know whether you said that rhetorically or you seriously.
I said it based on the substantive aspects of the law. There's some huge problems with the way the case was handled. There were over 750 limiting instructions that the judge had to give to the jury, in large part because the government insisted and the judge allowed the government to put in all of this extraneous evidence about Osama bin Laden. Now, when the judge made that decision, he almost went down the road where he had to repeatedly tell the jurors, That's for a limited
yes
purpose
or no, Andrew,
only
was it
disregarded.
inflammatory? Which is
the
what
second
Marvin said,
problem they
It was
had.
properly prejudicial, which is what it's supposed to be.
We'd have to come back and resume this conversation, but for now, my thanks to Andrew McCarthy, Marvin Schechter, and David Gartenstein-Ross. That's it for this edition of Due Process. We'll be back next week with more cutting-edge questions of law and justice. Till then, for Sandy King and all of us here at Due Process, I'm Raymond Brown. Thank you for watching.
What she did, she thought she was representing her client. She was speaking for her client, I'm sure. She thought she was exercising First Amendment rights. I think she probably stepped over the bar, but that wasn't so clear to her at the time. She just thought she was being a criminal defense lawyer zealously representing the interests of her clients.
Frankly, in law schools, including mine, we discuss the Lynne Stewart case as a warning to our students that you have to be careful here, that you are not end up in your zealousness to represent your client, that you don't end up participating in a crime yourself.
That message was sent loudly and clearly, but she need not be sacrificed in order for that message to have been gotten out.
There's still a sense that if you look at the bigger picture of all that has happened, and I'm just talking within the legal community, you get a sense that this is over the top and maybe something ought to be done to put a little bit of brakes on the government.
For Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy. Additional funding provided by Lawyer's Diary and Manual and online legal reference, elaw.com.
This is not a violation of the Great Writ. It's just they need to check to make sure they don't need to take one more shot. It's always too short a time with a subject.